Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, sir.
On March 28th, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer's supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry, sir.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant. Ordered him to stop. He refused to stop going towards the residence, Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe that they were in the process and believed him to be at the residence, and that's when this incident occurred.
Read it again, if you don't mind.
Yes, Your Honor. The law enforcement officer and Squad 5 of the Houston Police Department's gang division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant once again ignored the officers. The law enforcement officer grabbed the defendant and made him off balance and the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what. So I was originally reading the summary. I'm going straight from the agenda now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that there was that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I have nothing for that.
I find no probable cause in your case. Just be careful, man. When you get into a pissing match with
I understand.
who's going to win?
They are. I understand.
No?
Yes, sir.
All right.
I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Oh, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay, good.
On March 25th, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallsville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are
complainant,
you telling me now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color?
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she's willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't
me.
say anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case.
sir. Yes, sir.
And just, all right. Come on. Justin,
The only thing that she did wrong at the day and time was drive a vehicle.
with cocaine, alcohol in her system, beer in the car at a .20. And there's a fatality as a result.
Yes, sir.
Can you please read me what happened?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a four-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact, massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler, and the driver of the Amazon truck confirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop, excuse me. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol on her breath, red glassy eyes, and slurred speech. She was transported to the hospital, and a DRE arrived, and she was Mirandized and she waived her rights. She stated that an SUV was stopped in a lane and she tried to swerve to avoid hitting it and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving.
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze nystagmus, and officers observed a lack of convergence. They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done, and her blood, Your Honor, came back at a 0.025 for ethanol, and she had, yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's the offer that you have worked out?
We worked out an 18-month probation offer with 7 days as a condition, Your Honor.
I don't think that's enough. The fact that there's a dead body in this case, why is it not an intoxication?
It's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not, sorry, I'm not gonna say it. You have a dead body here. She has cocaine in the system. She's got foods in the car while she's driving and a dead body. I'm not down with that. No, we're gonna have to do something else, but I would be remiss a week in jail where we have a dead body.
Yes, sir.
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. I'm sorry. How many lives are now ruined because of this? Not only yours, how about everybody else? Every single day in Harris County, someone is maimed because of the DWI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication and manslaughter. But to me, a week is insufficient. It's not enough.
Yes, sir.
So,
We'll go back to the drawing board and get
Go
a
back,
reset, Judge.
but-
Yes, sir.
I'm ready to set this case for trial now. So unless we can work something out today, I'm saying it gets set today.
Yes, sir.
Okay.
All right, thank you, Judge.
Your Honor, I understand that a fatality did occur, but the reason why they weren't able to charge my client with intox manslaughter is because this accident was unavoidable. If you were
Unavoidable?
yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a .20. Let me ask you something. Have you ever done breath test? Have you ever blown into a breath test machine? Have you ever done those wet labs? You ever done that?
Your Honor, okay.
I'm serious, really.
Okay.
Have you ever done it?
I'll go one further, Your Honor. Before being a defense attorney, I was a lieutenant with HPD.
Okay.
So I'm above and beyond. I spent 3 years doing accident division. So not only did I investigated these. So my knowledge is probably more superior than anybody in the room. I spent 3 years picking up dead bodies. And that is a true and factual statement I'm making before the court. So yes, sir, I have.
I did, as part of training when I was a defense lawyer, I went to these classes where we took the breath test machines apart, did all kinds of experiments, did these drinking wet labs where you drink and then you blow into the machine. And the one time we did it, we downed a bunch of booze and I blew into the machine and I was lit, right? And I blew a 14 and I was lit, man. And all I did was I blew a 14, right? 0.14. She's at a 0.2.
0.025, Judge. 0.025.
0.02.
Yes, sir.
Okay. I thought you said 0.20.
No, sir, no, it's 0.025 with the cocaine and THC.
No, so she's not 3 times or 4 times over the legal limit, Your Honor.
We were discussing about Ms. Sanchez. We were discussing when for you to do your jail time. Should we have you do it immediately to where you have the baby in jail? Is that cruel and unusual punishment? But then again, is a dead body cruel and unusual punishment? You know, what's fair? What's not fair? I don't know. All I know is that you're charged with DWI. There's a dead body, but they just can't prove causation. And that's why you're not charged with manslaughter. But the fact remains is that we have a dead body. How do we reconcile that? You know, you're pregnant now, and I truly hope that you've treated your body well throughout that pregnancy. Because if you haven't, and you've used anything while you're on probation, you're guaranteeing yourself a life of babysitting of a potential baby that will have developmental, potential psychological, physiological issues that you'll have to babysit for the rest of your life, which is punishment in and of itself. It's not fun. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you guys have worked out is 30 days in jail as a condition to probation for 18 months. As part of the probation, does she have any prior DWI staff?
No, Judge.
Any other criminal history?
Juvenile history only, Your Honor, but nothing DWI.
What all were you wanting done on the probation? Correct.
Yes, sir. We are asking for DWI education class, a victim impact panel, guardian interlock, no refusal, no drugs or alcohol, random UAs, 80 hours of community service, and a $300 donation to MAP.
Is this how you understand the conditions, Ms. Sanchez? I will keep you to it strictly. I'm going to monitor you myself. You will report to me here to the court so that I make sure everything gets done well. If you are not in compliance, I will issue a warrant for your arrest. You will be put into jail, and then you'll be facing up to 180 days in jail. If you test positive for alcohol or any kind of drugs, I will put you in a treatment facility in the jail. Do you understand, ma'am? No alcohol, no dope, no driving. You must have what does she have now? Does she have a scram right now? Do we know if she's had any violations while she's been on? I don't think so,
I
right?
haven't
She hasn't
seen
any
any, Judge, no.
Okay.
She has a scram device at this time, Your Honor.
We have to figure out something about as far as the baby situation with the interlock or with the portable device. I will follow the state's agreement here. But like I said, I'm keeping you close to me. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, if possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. Hey, if you can do the repeat offender, do you get the education class? Did you say victim impact panel?
Yes, sir.
How many?
One.
One victim impact panel. You will be required to do a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. Guardian interlock, no drugs, alcohol, random UA. When are you set to deliver, ma'am? What day?
August 20th.
When do you think we should do the time?
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. That gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense, guilty or not guilty? I will find you guilty. We'll send you to the disagreement. Good luck to you, ma'am. Please